Next, we sit down for an in-depth interview with Rita Garman, the Chief Justice of the Illinois Supreme Court. Justice Garman talks about her path to the Supreme Court, as well as the structure of the Illinois court system, the effects of cameras in the courtroom, the process of the Supreme Court reaching a decision, and whether the Illinois court system is adequately funded. This runs about 1 hour.
Chief Justice Rita Garman, thanks for joining us on the Illinois Channel.
It's my pleasure.
Last time we spoke here, you were not the chief, so congratulations on becoming only the second woman in the history of Illinois to be Chief Justice of the Court.
That's correct. That is correct.
Let's get a little bit just for an introduction for those who aren't aware of your background. Where did you come from? And I'm curious, when you started your career, were you one of those people that always wanted to be a lawyer and have a career in the law, or did you kind of drift into it?
I am one of those people that always wanted to be a lawyer, at least from the time I was probably 15 or 16 years old. I was born and raised up in Oswego in Kendall County. At that time it was a very small county. It's not so anymore. But I lived in a rural area, farming community. My dad was a dentist, and my mom really helped my dad out in the office, but otherwise was a stay-at-home mom. And I decided that I really wanted to be a lawyer, and I really don't know why. I didn't know any lawyers. We had one lawyer in Oswego, and I don't really remember him. And I didn't. No one in my family was a lawyer, but to me it was a really appealing type of a career, and it was the kind of thing that you could go a lot of different directions. You could be in business, you could practice law, you could be in court. I couldn't possibly have seen myself as a judge at that time because there were no women. There were virtually no women in the judiciary at that time.
I was going to ask if you saw yourself as a judge or in some other capacity.
Not at all. In fact, it was after I began to practice law and was in Danville that it was suggested to me that I might consider being a judge.
And actually you practiced what I think as a state's attorney, was it?
Well, I started out actually with the legal aid office. When I got out of law school in 1968, it wasn't a very welcoming environment for women in the law. And I interviewed with various entities and offices, and at that time, people just couldn't see a woman lawyer. They couldn't see a woman lawyer talking to clients. Prospective employers would say things to me like, well, you're a nice lady, but what will we do with you? And I would say, well, what do you mean, what would you do with me? And they'd say, well, you know, no one wants to talk to a woman about their legal problems.
Now, was that when you first came out of law school?
That's when I first came out of law school.
And that was what, about 68
1968. And places, well, my husband was a lawyer, and they would say things like, well, how could you practice law if he's practicing law? Isn't that a conflict of interest? And they couldn't quite imagine that I could have an independent opinion, that they thought I would probably be his alter ego or something like that. So
it's amazing to think, just from a societal level, how our attitudes
absolutely
have changed as far as the role of women in society and in the workforce.
Tremendous change. And so I really got my first job really by happenstance, because we had arrived in Danville in September of 1968, and my husband started with a law firm that he was with through his career. And I didn't have a job, so I was looking around for work. State's attorney wouldn't talk to me. I couldn't get an interview in that office. As I said, the law firms were nice to me, but skeptical. They just couldn't imagine how they could possibly use my services. And one day, the chairman of the legal aid committee called me, and the legal aid director had walked out. He got into a disagreement with the board. It was a one-person office, and so he left, and they didn't have anybody. And at that time, legal aid was funded by the feds. It was funded through the Office of Economic Opportunity. And they were not sure whether or not they would be allowed to continue, whether the federal government would give them enough time to go out and seek a director for the office. So this legal aid chairman called me up and said, "What are you doing?" And basically said, "I know you're not doing anything, and would you come down and keep the doors of the legal aid office open? And we understand that It may close, you have to understand it may close, but we'd like you to come down and help as many people as you can for as long as we can keep this operation going, and we'll look for a director. So I agreed to do that with the caveat that, so well, I've never practiced law, much less run a law office, so you know, that's a huge undertaking. And they said, well, you know, if you get into anything you don't know how to do, we'll help you. And they were true to their word.
You were only about 24 or so at the time.
I was, and they were true to their word, and in fact, they became really my mentors. And they were very supportive of me, and I started at Legal Aid. There were 2 secretaries that worked at Legal Aid. They were tremendous help. They had been well experienced as legal secretaries. So they helped me, and I, you know, I learned to practice law just like you learn to ride a bicycle, and I just did it.
I often say you learn, the only way to really learn most jobs is by doing them.
That's right, and I did. So I went down to, I would go to the courthouse and file papers and take people down there for various cases that they had. And the clerks were very helpful to me in the courthouse, and the judges were very nice to me in the courthouse. And everyone, part was a very welcoming environment.
Do you think in that court system, like as you say there, as compared to if you had tried to get into a law firm, was it because one was the public sector and maybe the private sector law firms had a different attitude?
I think it probably was very helpful to me when I look back on it. And besides that, being with the Legal Aid Office, I had a lot of opportunity to be in court that you might not have if you were with a private law firm. Those opportunities are generally given to somebody that frankly knows what they're doing from the get-go. So I, of course, was feeling my way along, and I learned very quickly that the people that came to Legal Aid as clients, they did not care that I was young, and they sure didn't care that I was a woman. They were just so happy to have someone that would listen to their plight and try to help them. So I really enjoyed that. I really enjoyed the client contact and getting that kind of experience. And so I became well acquainted in the community and acquainted in the courthouse and with the other lawyers. And then about 10 months after I was at Legal Aid, one day the state's attorney came into the Legal Aid office, and he said, I'd like you to come and be an assistant state's attorney and handle all of the family cases, the juveniles and non-supports and paternity cases. And he thought that would be a good fit. So this is the state's attorney's office I couldn't even get into before. So I went to the state's attorney's office. There were 3 of us, a state's attorney and 2 assistants. I would be one of the assistants, and so I started doing the juvenile work in the state's attorney's office, and I was there for 4 years, learned a lot, and that was while I was in the state's attorney's office that one of the judges suggested to me that I might make a good judge. He said,
you know, I'm reminded of when we sat down and interviewed Mary Ann McMurrow, who was the first woman to be on the Illinois Supreme Court. I asked her, and I'll ask you, if the law is the law, what difference does it make if you're a woman?
Well, it doesn't make any difference, but most people at that time didn't have the vision. They could see a woman in a position like as a circuit clerk, a clerk position, secretarial position. You really could not see a woman in an executive position. And I think it was a function of the times. You know, when I went to college, the women were really given 3 options. You were in education, you were a secretary, or you were in nursing. And I thought those were all really wonderful occupations, but I didn't really want to do any of those 3 things. So I really wanted to be a lawyer.
It seems to me the diversity that might make sense on the court or be valuable isn't so much in terms of gender, but in background, so that when you had the background in the state's attorney, but also representing in legal aid, that if someone else ended up being on the Illinois Supreme Court who maybe had worked in corporate background, that would be valuable for certain cases.
Absolutely.
To what extent do those early years, when you're hearing a case where it might be regarding a minor child, or some aspect of this prosecution that you're reviewing, to what extent do you draw upon those experiences so early in your career when you're interpreting the case evidence that you're reviewing?
I think it's invaluable. I think all the experiences you have in life come into the mix and help you with the decision-making process. That's why I suggest to young people that tell me they'd like to be a judge, and they'll say, what do you advise that I do? And I say, get as much experience in as many different aspects of the law as you can, and in life, because those kinds of experiences are what form you as a person. You know, from being at legal aid, I saw people that were disadvantaged and that were taken advantage of in the state's attorney's office. Of course, I soon realized the plight of children in their cases and how important it was for children to have permanency in their situation. In those early years, my goodness, some of these kids had been in foster care for 8 or 9 years.
Yeah.
They grew up in foster care. And at the time, I think the view kind of was that children's cases are handled just the same as any other kind of civil litigation. And you know, we've become more enlightened. We realize that those years for a child are critical.
Right.
There's such a difference between birth and a year, how much a child grows and develops. In those early years, there are just changes that occur. So all that time is critical to little kids. And they really suffer if they don't have permanency, if they don't know where am I going to be.
You know, one of the things I want to do in the interview is a couple of things. One, remind people, and we'll go over some of the details of how the court works and functions, but when you're the chief, you can lay out some of your own initiatives or things you wanted to champion. I believe I'm right in saying that isn't domestic children's issues, I'm trying to think of the terminology that you wanted to use, but those children's issues are one of the areas that you wanted to focus on during your reign as the chief.
I have focused on those since early on, and early in my Supreme Court career, we formulated a special committee on children's issues to make sure that we were handling children's cases in the most efficient, expeditious way we could, considering due process at all, and which is of course critically important, but that we were making sure we got those cases through the court system, because time does matter. And I've carried that through. And at this juncture, one of the things that I'm pushing for as Chief Justice is that we examine what we're doing in the courts in Illinois to be as efficient as we possibly can with the cases that we handle. People are, when they have a case in court, it's the biggest thing in their life, whether or not there's a lot of money involved, or no matter what the issues might be, to them it's everything. So we really have to be sensitive to the fact that people are waiting, and they're waiting on a decision at the trial level in these cases, and then when it goes up on appeal, we have to be very mindful of the fact that they're still waiting. They're kind of in limbo. They have to get a final decision before they can move on with their life. So yes, it's a very important issue to me.
I might want to remind people, well, let's talk about, in the Illinois Supreme Court, first of all, I'm not going to ask you what you think about various opinions that would come before the court, because that's something that wouldn't be appropriate. But let's talk, just to remind people, the Illinois Supreme Court is one of, 3 layers, I suppose?
That's right.
Courts?
That's right.
And it's the top
layer,
the last stops, you might say, before going to the U.S. Supreme Court. But you don't hear the evidence, at least you don't decide guilt or innocence in cases, or you don't decide child custody cases per se.
No.
So let's remind viewers, how is the court system structured?
Okay. I like to think of it as a pyramid or as a funnel. And if you consider think about a funnel, turn it upside down. That's the way the court system is structured. At the bottom, or the biggest part, the mouth of the funnel, would be all of the 102 counties in Illinois. Every county has a circuit court. And that's where all the cases come into the court, pretty generally. That's where, whether it's traffic tickets or dissolutions or automobile accident cases or medical malpractice cases or civil damage cases of one sort or another, all kinds of criminal cases. They all come in, probate cases, juvenile cases, they all come in to the circuit court. And that's the level in the court system where there are evidentiary hearings and the person bringing the suit has a burden of proof to the court to prevail. In a civil case, it has to be by preponderance of the evidence. In a criminal case, it's beyond a reasonable doubt. So those cases go to trial at the circuit court level. They're handled by circuit judges and associate judges who are at that level of the court system. When a decision is made in the circuit court level, then the losing party has a right to appeal. And they can take that case to the second layer of the court system, which is the Illinois Appellate Court. There's a singular Illinois Appellate Court, and it has 5 separate districts. The districts are the same as the Supreme Court districts.
And those districts are just geographic areas of the state.
Right, 1 through 5. The first district is Cook County, and so that's like carving out the top little part, the crescent at the top of Illinois. The other districts run in bands across the state, top to bottom. The very top is the 2nd district, and then the 3rd district is Rock Island and Moline over to Joliet. The 4th district, the district I'm from, and where we're sitting right now in the Supreme Court building, runs from Quincy on the west to my home in Danville on the east. So it covers all of central Illinois, covers, of course, Quincy and Jacksonville and Springfield and Decatur and Champaign-Urbana and Danville. It goes as far north as Bloomington, as far south as Jerseyville. And then the 5th district is everything south of Effingham. So it runs from Effingham to Cairo. It has the largest geographic area of any of the districts, 37 counties in the 5th district. And so if your case is decided, for example, in Champaign County, then you have a right to take that case to the 4th District Appellate Court, which is here in Springfield.
And again, just in other words, you can appeal. You might
That's
have
your
been convicted of a crime,
right.
let's say, and you can appeal to
and
the
you
appellate
can
court.
appeal, you have grounds for appeal. And one of the grounds can well be there wasn't sufficient evidence to convict me of this crime, or there wasn't sufficient evidence for the party to prevail on this case. And the appellate court performs a error review process. They determine whether there was error made at the circuit court level, and second, if there was error made, is it sufficient to send that case back for a retrial? In the appellate court, there's no original testimony taken. All of the testimony, all of the witnesses appear at the circuit court level. So the appellate court is reviewing what's called the record, which is what transpired in the circuit court. A decision then is made at the appellate court level. Either it's affirmed or reversed. Affirm means the lower judgment's upheld, reverse means it's sent back or changed. The losing party then does not have an automatic appeal to the Supreme Court. Our function is different than the appellate court. We set precedent for Illinois. Our job is questions of law. We determine what the law is and if it's challenged, what the law should be. We determine whether or not legislation that's passed by the legislature across the street, whether that is constitutional under Illinois' Constitution. So we don't take cases just because someone doesn't like the decision that was made below. There has to be a legal issue, and we have to be convinced that the court needs to speak to that legal issue, because what we're doing really is framing the ground rules.
If I might restate it, so at the circuit level,
Yes.
The court would rule based upon what the rules are,
What the rules are applied to the evidence.
applied to the
Right.
evidence. At the appellate, they're going to review, did they follow the rules?
That's right.
And at the Supreme Court level, you basically make the rules.
That's
You might
right.
say,
Yes.
you know, there could be a case where it never,
Sure.
you know, as we, new technology, in fact, I want to get into technology
Uh-huh.
and how technology, which seems to be changing
Mm-hmm.
every other field,
Sure.
how is it, to what extent is technology changing the legal system? Have you,
Oh, changing us tremendously.
and does it impact the role of the court?
Oh, it does. You know, we're dealing with it on a number of different, you know, a number of different levels. Everything from the way our way things are filed in the courts in Illinois. And one of the things I'm pushing for in my term as Chief Justice is that our court system in Illinois become paperless, and that we move to an electronic format for the filing of cases and the processing of cases. And that those cases also will come through the appeal process electronically, from the circuit courts to the appellate court, and then of course up to our court. It has vastly changed the way legal research is done. When I went to school, you went to the books. You went to a digest and key numbers, and you read things, and then you went and pulled the book off the wall. And if you found when you found the case, then you'd read the case, and then whatever you liked out of the case or the quotes, then you'd have to copy that down. And then when you were going to cite it for a court, you'd have to make sure your cite was absolutely precise, and you know, put that in, and so forth. That's all now done electronically. They can.
It's amazing to think how inefficient it was now when we're accustomed
so
to,
much
you
more
could do a
efficient.
word search now
Absolutely.
and find it like that.
And see whether that word has ever been used in a case in Illinois. And I mean, it's changed legal research and made it so much more efficient, for example, that we really don't need the books anymore. And we have changed. The Supreme Court does not publish opinions anymore. Our opinions are all published online. They were previously published in volumes, in books. The court will save $500,000 a year in not having to publish books.
That's an amazing figure just
It's
right
an
there.
amazing figure. And so,
Is that also happening at the appellate and circuit levels, or is that,
Yes, it
again,
is.
part of your initiative to get them to adapt?
Well, the appellate court, of course, they're part of our, things are filed now electronically, not by paper, and so we've done away with filing the appellate opinions as well as the Supreme Court opinions. They're all online on the court's website. So, you know, it has vastly changed how, you know, how we operate physically. For example, in my office, each justice has an office in their hometown. So my office is in Danville. I had a library that's probably almost the size of this room, maybe smaller. You know, we continue to send volumes back to the librarian here in the Supreme Court, because we don't need them anymore, and we don't need to, you know, a big expense to our books, you know, whether it's digests or that sort of thing, were what we call the pocket parts, where they were updating them, you know, bringing in, because if you have a set of law books and they're not updated, they become useless, because you have to keep involved and abreast of the newest developments in the law. Well, that's a big expense. We don't need to do that anymore. All that material is available online.
The Illinois Channel, as you know, covers the mid-year meeting of the Bar Association in Chicago, and one of the interesting panel discussions that was last year as we taped this was a trial attorney showing how she's utilizing technology to illustrate in the courtroom, to illustrate her point that her
Yes.
client was damaged in
Sure.
some form or
Sure.
fashion. And I didn't realize until seeing that to what extent the courtrooms themselves are being wired and technology is
yes.
being utilized. So
Certainly.
people can sometimes see
Sure.
video, and it's far more interactive. It's no longer just the Perry Mason days.
That's right, that's right. And the other thing is, younger people today, if in my day, if you asked someone a question and you didn't know the answer to it, you'd have to go look it up. You go to the library and look it up. People today Google it, or go
Oh, they have
online.
Siri,
They
right?
have Siri. They ask Siri, and so they don't need that. And so it really has changed the way things are done. It has changed. It continues to be a challenge for us on dealing with jurors. For example, you have people on a jury in an automobile accident case. The judge may tell them, we don't want you to go online and try to do research about something. You have to decide this case on what's presented to you in court. People can go online and look at what the intersection looked like. They can go online and do their own checking. So it really is it's a constant challenge for us with keeping up to date.
Let me ask that. You said a judge who's the judge for that court
Yes.
case, but to what extent, and I don't know, does the Supreme Court, would you as Chief Justice, do you look at that and say, here's what the judges should be doing so it's not so randomly decided by individual judges?
We have various committees of the Supreme Court, and they study a number of those issues. And we have technology committees and other committees that look at those issues and make recommendations on how best we can handle these, what I'll call our emerging issues. But the world's changing very rapidly.
Another issue that came up in one of the panel discussions at the mid-year meeting, I forget the judge's name right now, a federal judge, but what was interesting is instead of the jurors merely sitting there and listening,
Yes.
that they were encouraged to not only take notes, but they could ask a question now and then.
That's right.
And one of the things that they found was that if the jurors were allowed to ask a question, it kept them more intellectually engaged in
Certainly.
the arguments or the evidence being presented.
That's true. That's Judge Holderman, the federal judge from Chicago. And he's been very successful with that, using that in the federal court. It is, we have seen changes over the years. Years ago, when I was in the practice, when you tried a jury case, jurors couldn't take notes at all. Even in the most complex of cases, they couldn't take notes.
It seems counterintuitive.
It is counterintuitive. Then a number of years ago, the court allowed the jurors to take notes. And so they would provide notepads and pencils and so forth. Well, that's really outmoded. But, today, this movement forward on, asking jurors, or if they want to ask questions, it's something that has to be, carefully monitored by the judge and in the discretion of the judge as far as whether they can ask questions and how that's handled, because you don't want to ruin somebody's case for them. But properly asked questions, I think, can help the lawyers focus on maybe on something they need to make clearer, for example.
Let me ask you a question here, and I may skirt the boundaries of getting a little too close to a pending case. But there were some big cases in the past that the Illinois Channel covered here, and there was no timeline for when the court would make a decision.
Correct.
And I found that somewhat interesting. I don't want to misspeak. It might have been the Price case. I know the case that was involved State Farm and whether they could use the original automobile makers' parts or not. And I thought, how does the insurance company, how does the local garage mechanic know what parts to use? Can he use replacement parts? Because I think it was about a year and a half or so before
Right.
the court issued a decision.
Right.
So sometimes a big case, and that was a pretty big case, the court took a while to issue a
Right.
decision.
Right.
The court is going to be asked to rule on the pension bill. The Illinois legislature passed a pension
Sure.
reform bill. The governor signed it into law, but they're holding it up until such time that it would come before this court, which it has not yet, and then at some point you would rule. But the question is this: when the court has a case like the pension case, and I know this is a little dicey because it's going to come to you, but to what extent does the court feel any pressure to make a decision in a timely manner, where I would say in the Price case, if I'm right, it wasn't necessarily very timely. Does the court take into consideration something that's not really a matter of law, but do you look in the broader context of how significant is it, how important is it for, let's say, the state to be able to function, for people to
Sure.
get a decision?
Well, you know, obviously I can't talk specifics either, but I will tell you that we are always mindful of the fact that there are people waiting for the decisions of the court. And we try to be as timely as we can possibly be without doing violence to the due diligence and the work that we must do. More complicated cases will take more time. It stands to reason. There are many issues that the court deals with that don't have ready answers. I tell my clerks in my office, you know, if these cases weren't so tough, they really wouldn't need us. They
Right.
would be
They wouldn't
easily
be here,
they
right?
wouldn't be here, or they would be easily decided. So there are at least two sides to most of these issues. In the Supreme Court, we sit 5 terms a year. We sit in January, March, May, September, and November. Our unwritten policy is that we will, if we hear a case for oral argument this term in September, whoever is going to write that case will submit a draft opinion to our colleagues by the November term of court, and then we'll consider it at the November term of court. That's a general rule. Many of the cases we have meet that time frame, but some don't. Some that are more complex, some that sometimes it's difficult to get. You have to get 4 votes in the Supreme Court. There's 7 justices. Everyone can write. Everyone can express their opinion on this particular fact pattern and the issues that are involved in this case. Sometimes it's very difficult to get 4 people to concur in the same analysis of the case. So it isn't that we're sloughing off or taking it cavalierly, or we're not working on it. We're working on it. It's just sometimes it's just really tough to hammer out what the court's going to do. And we know that whatever we decide, whether we decide it, and it's true with our administrative decisions as well as our case decisions, every case has a ripple effect. It not only decides the issues between these parties, but it affects every other case in the pipeline.
Yeah, I mean,
And
so you keep in mind when
We
you
do.
issue a decision in 2014
we do.
that it will be cited as case
That's right.
law and established law in 10,
That's right.
20, 30 years
Yes,
from now.
and it may not be on that particular fact pattern of that comes up or some permutation of that, but whatever we say in this case is the law. And so, you know, lawyers are very crafty with really parsing that language and quoting it back to us. So we have to make sure. I tell the clerks that work for me that we have to be extraordinarily thorough, and we have to show to the people, the parties that are involved, and to the public, that we considered every issue that was raised before us, and what our analysis was of the issues before the court. But we can't engage in any gratuitous comments, because sometimes it's very appealing to say something about about a fact pattern that may be absolutely spot on true in this case, but it might not be the case it might not be so true in the next development of that case. So we have to be very, very careful, and words do make a difference.
Well, and here's what's interesting, I think, maybe again to underscore for the understanding of the public. So a case comes, and right behind you is where the lawyers would argue before
Right.
the court, the bench, and you're sitting up there on the bench. Let's say 4 judges rule in favor of one side, 3 the other, but it's a split decision, but the
Right.
4, the majority wins.
That's right.
So the public might go, well, they ruled A versus B.
Right.
And maybe they just stop at the headline, but what you're saying too, if I'm hearing you right, is whoever writes the majority opinion, the writing of that opinion and where the words are so important is maybe more important or as important as the actual decision, because that language will be what actually makes the law going forward.
That's exactly correct. And so you have
To
be
that
very
end,
careful.
to that end, when we have a delay, to what extent is the delay based upon the need to precisely write the opinion as compared to merely coming to an opinion?
It's some of both. Sometimes people write. For example, we take a vote when we circulate an opinion, and we have a conference on that. We talk about them extensively, and then I take a vote. As Chief Justice, I take a vote, and we vote in reverse order. The least senior member of the court votes first, and the most senior votes last. Say it gets 4 votes. Well, it's called an adopted opinion. But then if it's not a unanimous opinion, people say, well, I'm against that opinion. They have an opportunity to write. So they will write, and then sometimes their writing is convincing enough that it might attract a vote away from the majority. So instead of 4-3, it may be you may lose the majority. At that point, then the author has to decide whether or not they'll make modifications to what they wrote to try to bring someone back aboard on the majority view.
If the Chief Justice is, do you assign
I do.
who writes?
I do.
If the Chief Justice is on the losing side of the argument, would you still assign who writes it, or is that then someone who's ever on the winning side?
Well, our cases are assigned before they're argued.
Okay.
So when after we've heard oral arguments, we go into conference and we briefly discuss the case, but not very thoroughly. And we take what's called an impression vote. That's based upon what I read in the briefs and what I heard out there in oral argument. Here's what I think, how I think this case will probably be decided. That is a non-binding vote. So then I say I'm assigned that case. Well, I might be the only person that thinks that that case ought to be affirmed. I am charged with going back to my chambers and writing that case, and writing it as the Supreme Court of Illinois should decide the case. Then when I present the case, I have to try to convince my colleagues that whatever I wrote is the way the Illinois Supreme Court ought to decide that. That's the way the precedent should be decided in this instance. Sometimes I get the votes. I mean, sometimes the people will read that, and because the impression vote is not a binding vote, and they've looked at it more thoroughly, they may come to the conclusion that's the correct analysis. So you may get the votes. So you write it regardless of where you were on the impression vote. But if for example, if it's a case where we'll say 4-3, and then you lose the majority and it goes, so it's 3-4, generally the person that wrote the dissent will then be charged with turning that into the court's opinion.
How do you answer, and I presume you may have been asked this in the past, someone might say, well, if the court is establishing what's the law, and you're all good lawyers up there, otherwise you wouldn't be on the Illinois Supreme Court, and you have such a divergence of opinion, now sometimes it's going to be unanimous,
Right.
but when you have a 4-3 decision, and we have split decisions on the U.S. Supreme Court,
Certainly.
I guess, who's to say what the law is when even 7 good lawyers can't come to a consensus?
Well, it doesn't have to be unanimous. As long as it's the majority opinion, that is the law. So you don't have the option of saying, well, 3 people or 2 people or 1 person didn't agree with it. You can't say, well, I don't go along with that because, I agreed with what the dissent said. The majority is what the law is, and so that's what you're bound by.
Well, that's the law. I guess the question would be, in other words, when you hear, and often it's interesting when we're listening to argumentation before the court here, and people are citing previous decisions to
Certainly.
support their argument.
Right.
It almost seems like it might be mechanical, but it's not. There's, I guess, always being human, some
Sure.
interpretation or, one of the interesting cases, I don't remember the case, and I don't frankly know how it was ruled on, but a tragic case, 2 young boys ended up dying in a quarry, freezing to death. They got stuck in the mud while they were playing where they shouldn't have been playing. And the question was, the quarry had insurance, I think it was $1 million per occurrence. So if 2 children died, was that 1 occurrence or 2?
Right.
What's fascinating, and I bring that up, is it's one of those things that it's like, it never occurred to me, and I don't know if it would have occurred to you, being on the case, until you're asked,
Right.
to how do you decide the language of what does an occurrence actually mean?
Sure. I mean, that involves a lot of research and thinking about not only what does it mean in this case, but what will it mean moving forward. So it's
And what are the ramifications
absolutely.
to society? And all
What
that?
are the ramifications of this decision? How will that impact?
You're obviously the Illinois Supreme Court.
Right.
Do you just look at Illinois law, or if there's a case, I'm told Arizona on a pension case, as an example, had a case similar to Illinois. Do you
Right.
look at what other courts in other states would have examined and what rulings they had, or do you stay within Illinois?
It depends. If we have Illinois law on it, we're going to rule on Illinois law. If it's a matter of interpreting a statute, we're going to use Illinois law. If we don't find anything from Illinois that helps us with the decision making, we can look to decisions of sister states. They're not binding on us. It's just like federal decisions are not district court decisions and Court of Appeals decisions are not binding on us, but they're authoritative, and we may adopt that reasoning or decide that is an appropriate way to analyze this particular fact or circumstance. So we don't go out looking for, gosh, what have they done in the other states? But sometimes sometimes we need to review kind of what's happened, or what other states do in analyzing a case when we really don't have anything here that will help us.
I don't want to wear out our welcome, but there's 2 other areas I just want to
Okay.
see if we can squeeze in. One of the initiatives that was started by your predecessor, Justice Kilbride, when he was the chief, was the cameras in the courtroom.
Yes.
The other, and whichever one you want to start with, I want to, as Chief Justice, you're the head of the judicial branch for the state. So you have to put together a budget and then even testify and go to the
Yes.
legislature and say, we need X number of dollars to run the court system.
Yes.
No one in Illinois feels they have enough money,
Right.
given the economic worries of the state. But how would you describe, for the people to understand, the level of funding for the court system? Do we have enough to get by? Are we woefully underfunded? How would you describe it?
Well, to answer your question in order, Yes, I'm continuing the court's initiative on cameras in the courtroom. We have a number of counties now that have approved and have pilot projects ongoing. We're continuing to review the experience of the circuit courts with cameras. To this point, there have been some, some things to work through, but it's been very successful. We find that I think we're finding that you have to have a media coordinator that works with the media and is the bridge with the court system. The media coordinator is an essential part of that success, and because they can talk media to the media side and also understand what issues might be there for the court. So I look forward to more of our counties becoming part of the project, and I think it's one of those things that eventually might be, why was it a big deal in the first place?
What do you say? And one of the things I'm proud of, the Illinois Channel, I believe, was the first broadcaster
Yes.
to have 2 cameras in this chamber
Yes.
to broadcast, because we kept arguing we want to be able to head-on shot of the lawyers as they address the court. And I remember one case, initially under the rules of the court, you only had 1 camera in the back. They had posters that were part of the evidence they were trying to project, and we couldn't see the posters on the camera.
Okay.
But as we said earlier in our conversation, this is a review of a
Right.
case.
That's right.
The guilt or innocence, let's say if it's a question of a criminal court, had already been determined, at least at the lower level. What do you think when we're televising, or if we're televising the circuit level court, if someone's accused of something hideous like child sexual molestation, maybe they've been wrongly accused. Do you worry about, if some case like that is televised, that even if the person is exonerated and they're walking down the street, the person may not remember that they were exonerated, but they'll remember the face, and that it has something to do with child molestation?
Well, there are risks, and more risks at the trial level with televising or putting these things online, and there are in the courts of review. As you say, there's no live evidence here. What we're talking about, legal arguments. So whether it's here in the appellate court, it's kind of a non-issue, because it becomes a question of how many questions the judge has asked and that sort of thing. At the trial level, you do have those concerns. That's why our policy reposes the discretion in the trial judge to make the ultimate decision as to whether they will allow cameras in a certain type of case.
You'll let them have the final say.
Yes, the trial judge and the chief judge of the circuit have the absolute discretion as to whether or not they will approve cameras for a given case. There are certain general rules. Juvenile cases aren't televised. You can't televise, you take pictures of the jurors at all. And those sorts of things, so to protect, protect the system. We know in reality, people get quite nervous about coming in to serve on a jury. Jurors are so important to our system. I mean, you need a fair and impartial jury panel. You need people from all walks of life, from all experiences in life. We were talking earlier about experiences to take you to the bench. You need that when you're having any kind of a decision making. So when you have a jury, it's really important that you have a cross section of people that have various experiences in life. You don't want to have people that volunteer. That's kind of a dangerous thing. They may have an agenda why they really want to be on that case.
Right.
So you don't really want that. And they get nervous if they think somebody's watching them or somebody's looking at them. I've had jurors that in the past that they're very uncomfortable with giving their address. They really don't. They don't want to do that. They don't really want to give too much identifying information. The court understands that, and so it's a balancing process. But I think the people that have participated thus far are big proponents of the process.
Well, and I know we have had feedback from different people just on watching the cases that we've taped here, and said how interesting it was.
Sure.
And in fact, some what struck me, it was the first time we ever televised the court. It was back, I think, in September of '03 or so. I had a letter from an attorney in Chicago who happened to be channel surfing and caught the arguments that we had, oral arguments we had taped.
I have a number of people that tell me when I'm out and about, oh, I saw you on the Illinois channel. I saw that, I saw that argument or whatever, and so you do get a lot of viewers.
Well, and what was interesting is here's a person who was going to be arguing a case before this court, and yet he said, I mean, it's something for, a plumber to be educated on it, but he said, I couldn't believe how much I learned by just watching what the courtroom looked like, how you asked the questions. I found that fascinating.
Sure. Well, that is a substitute for many times people come and listen to arguments and observe the arguments when they know they're going to have one upcoming, because they kind of want to get a feel of the territory. So it's a wonderful function that it performs.
On the question of funding, I know there was a murder case as an example just up in Lincoln, Illinois, about 30 miles north of here. And the reason I bring that up is the cost to the county that funded the courts was so egregious that it was really putting a great financial strain on the county. So,
Right.
Relative to the funding of our court system, is that something, one, are we adequately funded? And two, to what extent do you, or does the court at large, think maybe we need to look at a different business model as far as funding the courts?
Sure. Well, at the present time, the courts that are fully state funded are the Supreme Court and the Appellate Court. The circuit courts are not fully state funded. They are the responsibility of the various counties in which the circuit court is located. Some of our counties, a number of our counties, are in pretty dire financial circumstances. And so this is an issue we are aware of, and moving forward, an excellent question about where we should go. The legislature this year for 14-15 has given us a very respectable sum. We got almost everything we asked for in the court's budget. Our court's budget includes the salaries of all judges, Supreme, Appellate, and Circuit, and Associate. And it includes the operational costs for the Supreme Court and the appellate courts in all of the 5 districts. We also, of course, have an administrative arm, and that's covered under the court's budget. And then there's the biggest portion of our budget is money that goes to probation, and that's for the probation services provided throughout Illinois. And they are, that is allocated out to the counties.
Would that apply to the juvenile justice as well?
Yes, it does. Both adult and juvenile are covered under. They get reimbursement, partial reimbursement for probation officers. But as far as paying the costs of jurors, as far as any of the costs of running a courthouse, those things are not covered under the court's budget. They're covered under the county's budget.
And I'm sorry, did you say the local, like the circuit judge, is he paid?
They are paid. He or she is paid by the state. They're state employees. But the clerks of the court, for example, are county employees, not state employees. The Illinois State Bar Association, under John Thies, started an initiative or a project to study court funding. And that's been followed up. I think the Chicago Bar Association is very interested in a number of legal entities are interested in pursuing full state funding for our court system. Now that would vastly increase the amount of money that would be necessary to run the court system, because you'd be talking about funding the circuits in 102 counties of Illinois. But it would certainly standardize or make a lot better across Illinois what is available and what can be done. So it is something that we're taking a look at, but that isn't anything that's on the immediate horizon.
We got about 4 minutes left or so, but before we leave the funding level, there are going to be aspects of funding and justice that don't necessarily fall under your purview, but I'm wondering to what extent, not only you, but you, the court, and the legal community at large are concerned about it. Let's take something like, we hear stories about how rape kits, evidentiary rape kits, are not being tested on a timely basis because of a lack of funds. And then sometimes they will eventually get to something and they find out that here's a guy that has been out there and maybe has raped a number of women and wouldn't have been released from prison had it been tested earlier. I don't want to make it merely about the case of rape, but to use that as one example. Does the legal community of Illinois, does it look at a broader scale, or is it kind of where everyone just looks at their own little purview? But to say, hey, are we delivering justice to the people, or is this lack of funding, maybe at the Illinois State Police, impacting across the board justice to every citizen in Illinois?
I don't know that type of analysis has been done. The state police are part of the executive branch of government. It would take a real study by the state to determine the many aspects of delivering justice in Illinois.
I guess it's how we determine what justice means. Huh?
Well, absolutely. Well, just for example, how about handling of abused and neglected children?
Right.
Wards of the court through the Department of Children and Family Services.
And I have heard, by the way, horrible stories about that.
That's another aspect. At the present time, the court's budget for what I described, appellate, Supreme courts, and the probation services, and the administrative office, our budget is less than 1% of the state's budget. When my predecessor, Justice Kilbride, was the Chief Justice, he told the legislature that he would, since we were the third branch of government, he'd be happy to take a third of the state's budget. And they laughed, as you are. But these are the kinds of things that, moving forward, I think we're going to have to think about.
I would say, and I think I hear you somewhat saying, and Justice Kilbride would say, that you are a third branch. You're obviously critical. No one's going to say we shouldn't have court system.
Right.
And yet, it is true, not that necessarily you could get a third, but
No.
We need to look, I would say, as citizens, we want to have justice on a timely basis,
We do.
whether it's a civil case or a criminal case. We have to look and say, is 1%, whether it's 1% or 0.5% or 3%, it's not on a percentage basis. It's
Right.
do we have enough money to do the job?
Yes, and you referenced how important the system is. It is critically important to the continuation of our democratic society because we are the check and balance on the other two branches of government, and we ultimately decide whether legislation is constitutional. We ultimately decide how things are interpreted, how statutes are interpreted. So it is very important, and we do provide finality to circumstances and situations so that people can conform their behavior to the law or move on from situations that they've had. So I'm thrilled to hear your enlightened position.
Well, I would say, it has been a pleasure for me to be here not only today, but over the years covering the court and getting to meet some of the justices and being able to speak. And I would say, for all the angst that we have in politics so many times, I can say the justices in the court are all good people.
Well,
and I'm sure you would echo.
We're a collegial group and good people, and they work very hard. We try very hard to get it right, to make the best decision that we can make. And while we're not as visible as are some of our sister branches of government, nonetheless, we are critically important.
Well, we thank you again for being so generous with your time and visiting with us.
Thank you. Appreciate it.
Thank you. You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.